Do you remember the TV show Who Wants to Be a Millionaire with Howie Mandel? Well, I want to guarantee you that no jury and no judge is ever going to turn around to an injured victim in court and say, "Who wants to be a millionaire?" Do you want to know what this is all about? Come join me for a moment as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney practicing law here in the state of New York. You know, when you bring a civil lawsuit seeking compensation for all the harms and losses you received because someone was careless, maybe a doctor violated the basic standards of medical care, or a careless driver caused you harm, nobody's ever going to turn around and ask you, "Hey, who wants to be a millionaire?" Regardless of how much compensation you believe you are entitled to, you are only legally entitled to receive compensation for all the harms and the damages you suffered based upon the information we can prove to a jury to show that we are more likely right than wrong, that what occurred to you is true. You should know that there is a defense tactic that some defense attorneys will use during the course of trial to minimize the value of someone's injuries. And they will turn to the jury during closing arguments and say, "Listen, Mr. Oginski and his client are here asking for $5 million as compensation. We think that's outrageous." And now they'll go ahead and justify why they're not entitled to receive $5 million. Instead, they may turn around and make their own estimation of what they think the case is worth. Now, that's a risky strategy because now they're basically coming out and saying, "Hey, we acknowledge that you might be entitled to some type of compensation." But many times this is what they'll do. They'll say, "Listen, we don't believe they're entitled to any compensation because we did nothing wrong. But if you find that my client did something wrong, then we highly recommend that you only give her this amount of compensation." Why? And now they're going to have to justify to the jury why they think the client is only entitled to receive a small amount of money. So it's an interesting strategy to take with the jury to first say, "Hey, they're not entitled to anything, but if you find that they are, you should only give them a very small amount and not the $5 million that Oginski and his client are asking for." Sometimes that strategy will work, sometimes it doesn't work. But it's a very risky strategy because you now have to weigh a very fine line whether the jury will be receptive to listening or considering a smaller amount if you suggest it. Some defense attorneys won't even touch this strategy. Others embrace it. So why do I share this great information with you? I share it with you just to give you an insight and an understanding into what occurs in these accident cases and medical malpractice cases and wrongful death cases here in New York. You know, I realize you're watching this video because you have questions or concerns about your own particular matter. Well, your matter did happen here in New York and you're thinking about bringing a lawsuit, but you have questions that need to be answered. What I invite you to do is pick up the phone and call me. I can answer your legal questions. You know, there's something I do every single day and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.